Good evening to the students of the SLW670, even the other people also there. Amna Shida, Karibusana, SLW600, SLW616, SLW646, if I not be mistaken. Yes. Anyone can unmute and read what I posted on the screen? I said, anyone can unmute and read what I posted on the screen? Quick. Unmute and speak. Raymond, unmute and speak. Okay, doesn't matter because this is what I posted on the screen is welcome to the students of the SLW670, my virtual class. And here it is coming to the picture. I don't know why. Here it is gone. Okay. Yeah, on the case of the JC-Because from 9:10 to 10 p.m. And you may ask us, what is the Because case law? Yes, Because case law is nothing but intellectual property rights. The trademarks are concerned. It is also a big case law and the local case law. And I am the coordinator for these 4 courses of the masters this time. That is the first semester. That is me, whose name is given below. So now I would like to start my class. Yeah. This is the thing which I want to make it out. Yeah, this is Tayari. You can close down this one. Then the next one is I open the file. Okay, doesn't matter. Again, I can open the file. 670, yes, 670. And JC. Yeah, JC. This is the case law. Yeah, it is opening the case law. Yeah, you could see now the screen, on the screen the case law. Did you see on the screen what is the case law? Can you read? Raymond, can you read?
Yes, Professor.
Read.
In the commercial Tanzania, commercial division at Dar es Salaam, commercial case number 155 of 2018, JC Decaus SA, the first plaintiff, and JC Decaus Tanzania Limited, the second plaintiff, versus JP Decaus Tanzania Limited, a defendant.
Yes,
Judgment.
enough. See, when you look at both the parties, can't you see the similarity?
Yes, I can see it.
Because that is a JC, this is JP. So here,
yes,
a person who comes to buy a thing, he doesn't make that much a distinction of JP and JC because Decox Tanzania Limited is a very famous in Tanzania. It's of course, it's a multinational company having the malls in everywhere. It is based from the South Africa. See, why I am giving this judgment means every judgment of the local having the international standards of the landmark cases. A judgment I am giving you because in the PFIRAC model the case briefing is there. But in the problem question, I will give you the facts of the case law. Then I will ask you what are the issues are concerned, what are the rules are concerned, what are the applications are concerned, what is the conclusion is there. It doesn't matter, any case law is there, but the formula is the same. So here the judgment BK Phillips. Suppose if I say the case briefing, of course you don't have the case briefing, you have only the Iraq model. Iraq stands for, I stands for SEMA. I stands
Issues.
for
Issues.
then go on. Next. R stands for
Rules.
Rules.
then C stands for so A stands for
Application.
C stands for
Conclusion.
either you can say conclusion or the court held. And the A stands for both application and analysis also. So this is the method that you have to adapt it. Either it is a intellectual property case law or it is a international dispute case law. Doesn't matter. The rules are the same. For instance, you know how to drive. Do you know driving the car, four wheeler, Dorcas?
Pass on.
Do you know to drive the four wheeler? Why do you say pass on? Answer is yes or no. Answer
No,
is
Prof.
okay. What about Raymond?
Yes, Prof.
Do you know the how to drive the four wheeler?
Formula.
Do you know the how to drive the four wheeler? Four wheeler means car.
Yes, Prof.
Can't you drive if Mercedes Benz is there given to you?
Yes.
Can't you drive if the Toyota Crescenta is given to you?
No, no.
Why? It's a floor gear, not accelerator. If you are an
Both
expert
are
in the floor gear, you know, Najwa floor gear,
Yes.
gear changing, not automatic
Yes.
accelerator. If you know the driving
Yes.
of any car, either it is a Mitsubishi, or it is a Land Rover, or it is a Mercedes Benz, or it is a Toyota, any brand, you can drive it. Am I right?
Yes.
In the same manner, either it is a legal theory, or it is a intellectual property, or it is that ADR, international dispute resolution, but the rules are the same. So now I am giving the
Exactly.
judgment here. See, this is the case law, which is the intellectual property case law, and the BK Phillips J has given, and we need not worry about it because in the PFIRAC model, we need the judge's name because we have write the case law name first, and the case law name goes with the citation, and it should be in the middle of it. And Bharat, we can write the in PFIRAC model the judge's name, and later we write the crux of the case law. It is a case briefing is concerned. But we are doing only the Iraq model, hence we need not worry about it because in the examination I will give the facts of the case law to you. So when I give the facts of the case law, what you have to do is only you have to frame the issues from the case law and the rules applicable for the case law plus how it can be applied in the application, then the conclusion should be there. Then you should have supposed to know the what are the applicable persuasive value of the cases in the particular case law. That is also more important. Unless until you read the entire case law of the judgment, you know it, how to make it out. In general, suppose if you did not know it, I did not make it out, but because of your curiosity and the sharpness, you can easily make it the what are the issues are there. But every issue goes with the case law or sections or maxims or experts of the opinion of the people or the definition of the Black Law Dictionary or Encyclopedia or Americana. Now let us see that what the case law says. The plaintiff reveals that the first plaintiff is a family-owned company established in France by Jean-Claude de Cox. The first company is a family company actually. Jean-Claude Dax de Cox in the year 1964 by its shareholding structure. Second plaintiff is wholly owned Of course, a big company would be they know you give the license to the other people to act. So they give the license and the wholly owned and controlled by the first plaintiff, and it is alleged that the plaint that someone the sometimes in June 2015 JC-Because South Africa Holding Proprietary Limited acquired with the South African partner. Of course, South African partner has taken the total license to run the family business of the JC Decox, which is actually the French. And the Continental Outdoors, and here the Media Holding Property Limited, a limited liability company incorporated in South Africa, which was the ultimate owner of the former Continental Outdoor Media Tanzania. Of course, there is an understanding between them there because it is nothing but a principal and agent. For the agent activity, the principal is held liable. Am I right?
Yes.
Because it is under the vicarious liability. An employee is held liable for the employer is held liable for the activities of the employee, and a master is not master. A parent is liable for the activities of the children. Am I right? Because of the vicarious liability or vicarious liability. In the same way, if any partner does it, other partners are equally liable under the vicarious liability. Is the tort law concept. So the aforesaid acquisition necessitated changing the names of the Continental Outdoor Media Tanzania JC Dux Tanzania Limited. So ultimately they made the running in Tanzania with the JC Dogs Tanzania Limited, the second plaintiff, which is the first plaintiff brand. Actually, first plaintiff brand, but he has taken the permission and the license from the first man family, which is in France. The South African has taken it, and now the South African company, which is the second plaintiff, JC Dogs, is running the show. So it is the plaintiff's case, the defendant has infringed the. So here what I want to say, it is the plaintiff case that the defendant has infringed the plaintiff well. Who is the defendant here? You might have seen it. Who is the defendant here?
JP.
JP Decox Tanzania Limited is the defendant. So the plaintiff says that the defendant has using the name of JP Decox Tanzania Limited on the ground that the defendant company name, that is the JP Decox Tanzania Limited, is similar to the plaintiff trade company, that is the JC Decox. Only the difference is, what letter is difference? What letter is difference?
JP and JC.
C and P. J is common. The original is JC, but later on the JP has come. Only P is inserted over there. So the JP Decox Tanzania Limited is similar to the plaintiff trademark of JC Decox, because there is only the difference, only letter in the defendant's company name is, that is C, where there is a letter C. The plaintiff's name JC Decox and the defendant has put the letter P, that is JP Decox. Is it clear? Say yes. Only the one letter difference. Instead of C, he kept the P. Is it clear?
Yes.
Yes, Prof.
Yes, you have to give the answer, otherwise they cannot proceed. So the plaintiff alleged that the two names JC Decox and the JP Decox are the confusingly similar. Moreover, the plaintiff alleged that the first plaintiff has been globally using the name JC Decox since 1964 and registered it as a trademark in 135 countries. How many countries?
135.
How many countries are there in the world now? If you know it, you tell me. If you don't like, say pass on.
Pass on.
194. But 3 are still lingering to get the recognition. The UNO 194 countries are there. In the 194 countries, and the JC Decox is 135 countries is there. So a good monopoly would be there. Like McDonald. Najwa McDonald.
Yes.
It is also having the many countries and KFC,
Yes, sir.
KFC, Najwa.
Yes, Prof.
What is that?
The restaurant.
No, what it does it sell the brinjals or bamia?
Bites,
What bites? Chicken, say
chickens.
chicken.
Yes.
Yes, it is the worldwide also. The McDonald's are there, and the pizzas, many other. Even I have forgotten because my daughter knows many things. Even my wife knows. Okay, now let us come to the kind. Furthermore, the plaintiff alleged that sometimes in September 2014, the defendant registered a domain under the name www.jpdecox.com. Who defendant? From where? Tanzania. The same displayed content that were basically showing that it was a competing with the first plaintiff business, who is the family business of the France, and which is taken by the South African company. Upon being aware of the aforesaid domain name of the July 2014-15, the first plaintiff lodged a complaint at the online ADR Center for the JEC Arbitration Court, CAC, on the ground that the defendant domain name aforesaid is confusingly similar to the first name plaintiff trademarks Decox, and the plaintiff was decided in the favor of the plaintiff. So first he filed a case in the tribunals, and there he wins, because one cannot keep a similar name which is already registered on the trademark. The reason is people doesn't make that much difference of the JC and JP. And there he got it, the first, in favor of the plaintiff, first plaintiff, who is the original member of it. In addition to the above, plaintiff alleged that the October 2015, the first plaintiff lodged a complaint with the World Intellectual Property, that is WTO. Sorry, WIPO. WTO means World Trade Organization. WIPO means it's the Intellectual Property Organization. An arbitration and mediation center at the Salem Alley in the respect of the domain name registered at the jpdecox.co.tz, which featured in the defendant website on the ground that the same was confusingly similar to the first plaintiff trademark JC Docs. That complaint was also decided in favor of the plaintiff. Even there also he has made to the WIPO. And there also they have decided, yes, it is a confusion would be there. Hence, no one should have to keep such a domain name, because people will be confused over there and thinking that there is the same company is selling it over there, and they will take the product, and the original company product, nobody would purchase it, and hence there is a financial loss to the first company or the first defendant, first plaintiff. So, moreover, the plaintiff alleged that through the legal counsel, they demanded the defendant to stop using the name of JP Docs Tanzania Limited, but in vain. But they requested to stop it. And thus, in this case, the plaintiff prayed for the judgment and decree against the defendant as follows. Then he filed in the Tanzania. So, a declaratory order that the defendant use the name of JP Docs Tanzania Limited infringes the first plaintiff, and which is a JC Decox, basically French, but later on it is taken over by the South Africa company, because they are combined together file a case. And first plaintiff, well known as the JC Docs, it's a family name, and a permanent injunction restraining the defendant, its agents, representative, servants, agents, and or any other person acting under its instruction from the trading or advertising or marking or any other way dealing in the JP Docs or any other name closely resembling the plaintiff names as the name, including the JP Docs resembling the trademark of the JC Decox registered in favor in the first plaintiff. So the permanent injunction is issued by the Tanzanian court not to use in further JP Decox, because it is confusing. Only the one letter C is different, and hence they gave the permanent injunction not to sell, not to canvass, not to go for the business. So a provision order restraining the defendant. Who is the defendant? JP Decox. Am I right? Say yes.
Yes, Prof.
Okay, its
Yes,
agents,
Prof.
representatives, servants, agents, or any other person acting under the instruction from the holding itself to as the associate or affiliated to the company of the plaintiff of JC Docs Group. So they made it very much clear to anyone not to go further. Prohibition order will be given. So an order that an inquiry has a damage as to the plaintiff option and an account to be taken from the defendant and the profit that the defendant has made the trading under the name of the JP Docs Chandana Limited from the time that the defendant was prohibited from using the domain of the name and the date of judgment and the payment of the all sums found to due to upon each inquiry and account to be to the plaintiff. Merely stopping to not to go further, it doesn't give the justice. Whatever the amount he claimed, whatever the profit he got by using the JP Decox, people has purchased, it is a JC Decox because it is having the business in 135 countries. Is it clear?
Yes, sir.
See, for instance,
Prof, may
Johnson
you
and Johnson, what they produce?
Person.
They produce, number one, the children, kids, infants, all the accessories like a panties and their what I say chakula. It is mixed with the lactose or glucose or milk. All the products, including the some products of the cosmetics like soaps. Johnson and Johnson soap. Did you know it?
Yes, Prof.
What is that soap name?
Baby Johnson.
Dettol.
Okay.
What is the soap name?
Data.
Yes, appreciate. So they enjoyed the profit also. They say not only the injection, but the whatever the profit that he earned, it should be returned to the first plaintiff. An order of the destruction and the delivery of the plaintiff or the arbitration upon the youth printed matter, label, or outdoor advertising material, the use which would be the breach of the permanent injunction and the prohibitory order sought by the plaintiff. So the plaintiff got a permanent injunction of the prohibitory order stating that they are not supposed to do such a business in further, plus whatever the business they did it earlier with the name of the JP Decox and whatever the profit would be given over there, that profit share should be given to the original company because he exploited the brand of a particular company. An order for the compensation for the loss or goodwill, and an order for the punitive and general damages, they claimed it. Interest at the rate of the 12% per annum, declared amount awarded to the date of judgment until the full payment. Until the full payment will be paid over there, the 12% interest you should have to pay it. The cost of the suit, even whatever the amount he incurred over there for engaging the counsel, the cost also should be made over there. Interest of the rate of the 8% per annum being the court's rate on the cost from the date of the judgment until the full payment is there. These are additional things also given. Such order relief of the honorable court may deem fit as to grant, but again they will wait. Whatever the order of the court deem fits, they can grant it, which is not asked there in the plea. So on the other side, the pleading revealed that the defendant is a limited liability private company. It was duly incorporated in Tanzania under the Companies Act of 2002. And the defendant has given his own version. Because it is registered on the Companies Act of 2002. In the year 2014, it also deals with the door advertising business. It is a defense that the defendant denied to have infringed the first plaintiff trademark on the ground that it was duly incorporated and registered Tanzania by the registered company 7th August 2014. He says that we registered the company and we are doing the business. And this prior to the registration of the second plaintiff trademark, there is a Tanzania since the changes of the second plaintiff name into the content name were effected in the June 16. But before that one, the second person also entered and who is from the South Africa in the 2016. So the defendant further contended that the first plaintiff trademark, there is a JC Decox, was registered after the defendant was duly incorporated the business registration of the licensing agency, there is a BRELA. And here the trademarks is concerned. The BRELA is the agency which will take care of it and complying with the legal requirements. Therefore, the defendant name is protected under the Companies Act 2002. It is protected under 2002 because the company is registered under it, but the product of it, a trademark, could be registered under the BRELA, the Trademarks Act. So the defendant did not dispute that they registered a domain using the company name, the JP-Because, as alleged in the plaint. But he did not deny that JP-Because that he used it. Yes, at the final pre-trial conference, the following issues were framed by the determinants of the count. So whether the defendant name JP-Because Tanzania Limited and what's JP-Because infringe the plaintiff trademark JC-Because. If you look at it, a common man also says there is an infringement or there are not. Sema,
There is.
there is a clear infringement is there because people will not only observe the only one letter because they think there is a JP-Because, but actually it is not JP-Because, it is the original company, it is JC-Because. So, what refers as the parties entitled to it, and the hearing of the matter, the Lend advocate Thomas Sipemba and the Lucas Elenge appeared in the plaintiff, whereas the defendant was represented by the Lend advocate Frank Molango. Both sides have one witness each. The plaintiff witnesses and Mrs. Jane D. left. Of course, he is the plaintiff one, and second plaintiff is sales manager, whereas the defendant witness is Elias Richard Moshi, the defense witness one, and the defendant chief executive officer. But overall, that what I want to say is they have taken the name is in a confusion because there is only one letter is difference. The original company is JC-Because and the later company is JP-Because and the plaintiff trademark JC-Because. Hence, there is the infringement. They made it very much clear in their arguments. So when you go to for the further thing also, as per the plaintiff exhibit one, a certificate of the registration of the trademark JC-Because in Tanzania in different classes of the trademarks. The exhibit P2 collectively certificate of the registration of trademark JC-Because in the following countries: European Union, Canada, France, Australia, United Arab Emirates. Exhibit they have given Kenya, Malawi, Swaziland, El Salvador, Zimbabwe, Japan, Oman, Mongolia, Colombia, China, Mexico, Ireland, Thailand. They have made the P4 collectively, and Puerto Rico, Nigeria, Zambia, Nicaragua, Panama, Peru, Myanmar, Brazil, Mauritius, Dominican Republic exhibit, and certificate of so total 134 countries exhibit they have shown there in the court. That the JC-Because having the multinational company in 134 countries and including the JC-Because Tanzania Limited, and where the rights are given by the second plaintiff from the South Africa. So the publication and celebration of the 50 years anniversary of JC-Because also shown over there. 50 years anniversary. In addition to the above, of course, they have given the many other reasons. Yes, I could hear the sounds from you. Please unmute it. Okay, they have given the powerful, that is the prosecuting witnesses and defendant witnesses and WTO arbitration and mediation centers against some Ali respect of the domain name registered as the so-and-so places. They made everything to the Court of Appeal in Tanzania. So JP-Because in the defendant domain is a bit like a www.jpdcox.com. Both complaints were decided in favor of the first plaintiff. They say yes, because it is very similar, it is a infringement of the trademark. So it is in favor of the first plaintiff and second plaintiff is given over their decision. Respect to the both the complaints are there. So if you go on seeing that, in the other hand, in this witness, the DW1, different W1 stated the follows, that the defendant was duly incorporated the Tanzania on 7th August 2014. Doesn't matter. But the only point is, it is a confusion would be there because of that thing. So second plaintiff who sought a legal protection belatedly should be deregistered. So he said you should be deregistered because that company is having the 134 countries multinational company, that is a JC-Because. And now here come you are the JP-Because of Tanzania that you made it recently. So these are all the arguments they made it over there. in their closing submissions, what they said, a land advocate in an agreement that according to the Section 31 of the Trade and Service Marks Act, which is there in Tanzania, there is a Trademarks Act. Once a trademark is registered, becomes a protected against any infringement. Similarly, it is a common ground that it acts as a amount to trademark infringement as defined in Section 32 of the Trademarks Act. For ease of the reference and understanding coming discussion, let me reproduce there in the provisions of the section 31 and 32. But you can ask that why the Tanzania has registered such a mark, whether they do have the knowledge or not. It is the person who wants to register it. He should say that there is no similarity of such a nature. He has to give the undertaking. Am I right? When you are writing that thesis, you give the undertaking. The thesis is not copied from any other place, not is submitted to any other university, and whatever the
Professor,
which is yes,
I have the question.
yeah. Please ask.
I'm trying to connect in on how it should be applied on the dispute settlement.
Yeah, dispute settlement is also international dispute settlement. If such a matter comes in the trademark circles. In the dispute settlements, you can approach the international organizations, international agencies, regional bodies. Is it clear? But here, international convention are there. Berne Convention is there. And the Rome Convention is there. Many other conventions are there. And by that one, we can file a case, depending on what the nature of the case law is concerned. Even the local case law also comes under the ADR here. For instance, we take a Dawson case law.
Yes, Professor, but is it right or it is as a procedure to file an international court to the domestic court, international dispute to the domestic court?
Yes, suppose if he finds that there is injustice caused to me and he filed a case here, if really injustice caused to the person and not following the natural law, not following the procedure, at that instance, yes, local court can also have the direction. But the nature of the contract, what is the nature of the contract that you made with there? Like that, I told you already in a Dawson case law, it is the nature of contract. Whatever the dispute should be there, it is the UK international law would be come to the arbitration. But the Tedesco failed and they filed a case in the Court of Appeal, the High Court. But High Court confirmed the arbitral award. Again, they approached to the Court of Appeal. But the Court of Appeal also upheld the decision of the High Court that is the same arbitral award holds good. In the same manner, one can approach it for getting the justice because the JC Docs, he filed a case in the International Court of the the World Intellectual Property Organization, and there he got in his favor. But he wants to file it because the party is from Tanzania. The another party is from Tanzania. Tedesco is also party from, say,
Tanzania.
Tanzania. So they can file it. The injustice caused over there. And again, they will check it whether really there is an injustice caused over there because the procedure they did not followed. Then they can make it out. Otherwise, they cannot make it out. Is it clear? Is it
Yes,
clear?
Prof. Yes.
Yeah. In the human rights, first they will make the domestic court. Next, they can go to the regional court. Suppose the High Court did not give the human rights protection to you, then go to the Court of Appeal. If the Court of Appeal did not give it to you, you go to the People's Rights Court in Arusha. the regional court of the African. Am I right?
Yes, Prof.
Okay, there is a schemes are there, the chains are there. With that, it can be followed. So whether it is infringement is there, answer is yes, because the section clearly made, because JP and JC, which is confusing in nature, and people buy it. So they have given the many other explanations under this JP Deluxe, and how they wrote it and what they did. In fact, while responding to the questions posed into him during the examination, DW1 means defense witness, admitted the defendants and the second plaintiff name are similar to those claimed they are not confusingly similar. He contended that the similarity those names happened by the coincidence. Either it is a coincidence or intentionally, doesn't matter. It's the infringement of the trademark. Clearly. So they have given the many other reasons. Now back to the facts of the evidence adduced in this case. It is not in the dispute that the defendant company was incorporated in Tanzania prior to the registration of the first plaintiff trademark in Tanzania. It's a different issue. The company has made the later part it, but the first company is only the JP. Though the same was registered in other countries, W1 tendered the court and 28 certificates of registration of the trademark JC Docs in the different countries, exhibit P3, P4, P5, they made it. So, even if it is made later in the Tanzania, doesn't matter. But it is amount to the infringement of the trademark. Even though the JP Ducox has made the registration in Tanzania, Kwanzaa, and the JC Ducox Pili. Is it clear?
Yes, Prof.
So thus they will make in Tanzania have been registered in different countries located in different continents. No wonder during the hearing no evidence was deduced by the defendant to challenge the plaintiff allegation that the trademark JC Ducox is null worldwide. That is disputed. It is a worldwide node, the company, because it is a 134 countries it is there. So here what they have given is, in my considered opinion, legally it is not correct of a person to register a trademark or a business or company name confusingly similar to a widely used and known trademark with well established goodwill in its business trade. So when it is established business trade would be there, such a mark should not be used. Either by changing the slight difference or, Puma shoes. Najwa, Puma shoes. Puma shoes, Najwa. Say yes or no. Say yes or no. Sir, we don't know.
No.
Puma, P-U-M-A, Puma shoe. Sports shoe.
Yes.
Right? Sports shoe.
Yes.
Adidas, sports shoe. Najua, how sijui?
Najua.
If you say sijui, you are said to be the kijiji mtu. Or shamba mtu. So, yes, welcome back to the second session of the today's class, because the continuation would be there because only a little portion is left over there, and that's what I would like to continue. And participants, are you hearing me? Yes. Yeah, if you are hearing me, just unmute and say that yes, continuation would be there of the first session, is the second session. So the trademark is not registered, is her country. It has to be noted that trademarks goes together with the investment in terms and goodwill in a particular business. So overall what I want to say is, the DW1 means defense witness 1 admitted that at the time of the registration of the defendant company, he was aware of the existence of the first plaintiff trademark and business. Because that company existed in 134 countries in the world. And surprisingly, he decided to register a company with a name confusing similar to the first plaintiff, well-known trademark for a business which is similar to one conducted by the first plaintiff. Not only that, the evidence adduced was revealed that J.C. Ducox is not only the known worldwide but also bears the family name of its founder, Mr. Jean-Claude Ducox. This is proud to be the exhibit P6 and the documentary 50th anniversary of the J.C. Ducox, which contains the details on the background of the trademarks J.C. Ducox. So, in any way, the defense witness cannot make it on anything because they know that this J.C. Ducox is already there before they enter into the market. And moreover, the decision made by the WIPO, the World Intellectual Property Organization Arbitration and Mediation Center, an online ADR center for the ZEC Arbitration Court. And this is also a court which will take up the issues when such an infringement has occurred in any one of the intellectual property, including the trademark. And indeed, J.C. Ducox is a worldwide known as number one outdoor advertisement company. So in short, what I want to say is, in the fine case law, Logistic Limited and two others versus Agility Logistic Kenya Limited, this is a civil case number 840 and 210 for the persuasive value of the Court of the Kenya, that is a Milimani Commercial and Administrative Division 2012, that is EKLR, that is Electronic Kenyan Law Review, cited by the Eringe. So this is another persuasive value, they cited it and they emphasized it. It's a well-known mark, J.C. Ducox, and the defendant cannot equally enjoy the virtue of the registration of the company under the Companies Act. If he is registered under the Company Acts, he cannot enjoy it because it is clearly the infringement of the trademarks. So similarly, in the case in hand, the fact of the trademark J.C. Ducox is worldwide known, as I have elaborated here in above, and that the defendant was well aware of the existence of the said trademark before the defendant company was incorporated in the Tanzania. So the defendant companies came later, but the plaintiff, which is a family name, Jean-Claude Ducox, and hence the production of the obtained by the registration of the first plaintiff trademark in the Tanzania for override the production obtained by the defendant by the mere registration under the Companies Act. So if you register in the Company Act, you will not hold good. You have to register in the Trademarks Act also. Suppose if you registered also, and if you know that there is an existence of such a company would be there with a slight change of the JP to JC. The original company is JC and your company, the next defendant company is JP. So notwithstanding the fact that the defendant company was incorporated prior to the registration of the first plaintiff trademarks in Tanzania. Yes, it is an obvious factor. And coming to the relief, the parties entitled to since have already judge make the statement made a finding that the defendant name JP Ducox Tanzania Limited is confusingly similar to the first plaintiff trademark JC Ducox because only C and P letters are different. I hereby enter the judgment against the defendant as follows: that the defendant used the name of the JP Ducox Tanzania Limited infringes the first plaintiff well-known trademark JC Ducox, and the defendant, its agents, representatives, servants, assignees, and or other persons acting under the restriction are hereby permanently restrained from trading, advertising, marketing, selling, in any other way dealing in the name of the JP Ducox or any other name closely resembling the first plaintiff name or trademark JC Ducox. The defendant is hereby ordered to destruct all printed matters and labels on or for outdoor advertising materials, the use which would lead to the infringement of the first plaintiff trademark, that is the JC Ducox, or breach of the court order issued therein. As regards the plaintiff prayer for an order that an inquiry as to the damages or the plaintiff option on account of the taken by the defendant of the profit that the defendant has made by trading other name JP Ducox Tanzania Limited, from the time the defendant was prohibited from using the domain, that is a www.jpdecox.co.tz. And up to the date of the judgment, I find that the same to be the untenable. Yes, it is clearly mentioned that from here onwards, in any form, the second defendant company should not supposed to do either the product or the labeling or the advertisement. Any other thing should be destroyed. The court cannot act as an executing court in the respect of the orders that were issued by the WPO Arbitration and Mediation Center or at the online ADR center of the JEC Arbitration Court, because the other courts will be there again. How we can use the execution of such an order of the WPO and CAG, that is the JEC Arbitration Court? Because execution is another important, unless until there would be a binding factor would be there for one country to another country having a good relation with them, then only that is the recognition and enforcement of the foreign judgment would be there. So this judgment of the first one, respect of the controversy pertaining to the use of the defendant company name, JP Decox Tanzania Limited, thus under the circumstances, there is no basis for this court to grant the order for the inquiry on the profit obtained by the defendant by the trading and its company registered by the registrar of the company from the time it was prohibited and using the domain name of the www.jpdecox.co.tz as provided by the plaintiff. So, in addition to the above, to my understanding, means the court understanding, there the judgment is given by the judge. The copies of the decisions made by the WPO Arbitration Mediation Center and the online ADR Center of the JEC Arbitration Court, in the both the places first defendant won it, and it is in the favor of it, and the judgment is there, which is shown as an exhibit P8 in respect of the use of the domain, that is the jpdecox.com, and so were brought into the court to prove that the trademark acts of JC Decox belong to the first plaintiff and the use of the company name JP Decox Tanzania Limited is leased to the infringement of the first plaintiff trademark. Clearly, not the purpose of moving the court, among the other things, the effect of the execution of the orders issued by the institution. As regards the prayer of the payment of the compensation for the loss of the goodwill and a punitive and general damages are concerned, I find myself in agreement with the Elinge, and who is arguing on behalf of the first plaintiff, and that the defendant deserves to be condemned to pay the punitive and general damages, which in my view will also cover the loss of the goodwill, and the defendant decided to use the company name similar to that well-known worldwide trademark of the JC Decox. For the outdoor business who has to obtain the advantage out of the goodwill established by the first plaintiff. So, thus, the judge himself says, yes, he has enriched himself a lot by using such a standard name of the JC Because, which is worldwide and having the branches in the 134 countries. The evidence adduced by the PWD1, that is the prosecution witness 1, also shows that the plaintiff suffered from the damages following the defendant infringement of the trademark, as it had to incur the cost and spend time and energy to deal with the said trademark infringement. And it is also evident that among the damages suffered by the plaintiff is loss of the goodwill. And therefore, I hereby order that the defendant shall pay the plaintiff a sum of Tanzania shillings, I think how much it is? 3 millions. 1, 10th, 100,000, 10,000, like, 3 millions, and the Tanzania shillings of the 20 millions being the punitive and general damage respectively. Of course, they have added that some damages would be there as a defendant should pay, and the punitive damages also there, and the general damages as respectively. The cost of this case shall be borne by the defendant. Whatever the expenditure would be there, that is borne by the defendant only. In addition to that, the mental tension created to the first company and the goodwill would be there, and the stress and strain would be there, and time consuming would be there. Hence, general damages as well as the specific damages also awarded in the form of the Tanzania shillings. That is 3,000,000, and another is being punitive damages and general damages respectively. Punitive damage is 3,000,000, and the general damage is 20,000,000 / the cost of this case can be borne by the defendant. Hence, the date of Dar es Salaam on the 4th day of the February 2021, it is decided by the B.K. Philip is a judge over there and stamped by it and signature by over there. So now, the case law, which is nothing but the infringement of the right of the intellectual property. So when you compare with the ADR, that is the alternative dispute resolution is concerned, don't you think that the Tanzania also having the ADR cases? I saw Raymond is present. Give me the answer. See, international court of justice will do. Regional court or arbitration can do. If it is a municipal, remand. The respective country will deal. Are you following me? Rehman, are you there? In the international level,
Sir,
international courts will come to the rescue. In the regional level, regional tribunals or the agency will come. Or diplomatic methods, or educative methods, or institutional methods and enforcement machinery, or the national or state municipal laws. When one of the parties from the state. In that instance, you can also file a case in the country where the dispute arises. Either it is the intellectual property, or it is the arbitration, or it is the law and economics. Doesn't make any difference. Injustice is injustice anywhere, irrespective of the area and the transaction. So depending upon that one, the cases will be dealt in the municipal courts also. So in other branches also there is a municipal laws are there, municipal courts are there, and the local cases are there, and that cases that we will discuss, because the first question is the compulsory question in the form of the Iraq model problem solving question, and hence every person in that particular country should have to know how it can be executed in the municipal courts. Raymond, are you there? Say yes. I
Yes,
cannot
Prof.
see your microphone. That's why I'm asking you. So
Yes,
this will
Prof.
be applicable in each and everywhere. And tomorrow is a Saturday. And a Saturday term is for the, I believe it is for the law and economics. Because your term came on the Monday and Friday. Not Friday, Thursday. But yesterday. Anyway, that yesterday you could not listen, it doesn't matter. But again, we'll take the class if you are willing on Saturday evening. Of course, Saturday evening is the, I will take the law and economics. And Sunday I can continue your class if you are willing to listen from same 9:10 to 10 o'clock. I will deal it. So by that time that I would like to take, and I will post it also. Either you listen any case law, doesn't matter. But the principles are the same. So now I give the facts of the case law today, of this particular. Let you presume it. At that instance, what are the persuasive case laws are there? Only one or two case laws are given. Plus, and the trademarks act also, the section is given. And the WTO, that is the World Intellectual Property Organization, WIPO, the decision is given. The JET ADR online also be given over there in exhibit. And these are all the supporting things that you have to make it out when you are framing the issues. So when you are framing the issues, what are the supporting documents should be there that you have to keep in the rule? The rules consisting of either the cases, which is a decided cases, or the Latin terminology like the maxims, or sections and its enactments, or the Black Law Dictionary, or any other experts, or the Encyclopedia of Americana, or the Encyclopedia of the Britannia, you should come into the rules. And now you can ask me the Raymond, because I did not get the answer from you when I asked it. Yes, you can ask me. Again, I could not see your microphone. Yes, now I saw the microphone, but I don't know whether it's a problem of your Matanda or not. You can unmute and speak and ask me. I already given the answer to your question. You take any case law, doesn't matter. But the point is, the facts we will give in the examination, and you have to frame the issues. You have to frame which are the relevant supporting cases. You can do so only when you could read the cases. And I will ask the same cases which I discussed in the class. If I did not discuss it also, in the later part also, like I discussed today, yes, tomorrow you cannot say that, sir, you did not make such a thing would be there in the class. It's a proof that my recording is a proof. So with this, I would like to stop my today's lecture, and I will intimate you when I am going to take the any case law and its analysis, either in the Iraq model or the PIF-Iraq model, that I will make it out. And if you have any doubts would be there, you can contact me, because I am in the public domain, and you know my WhatsApp number, you know my local number, and you know my email ID also. And I am here to serve you. I am here to serve you. My knowledge should not die with me. My knowledge should be disseminated before my death. That is my intention. Yes, with this, Raymond, you can want to speak, you can speak me. I saw your microphone now.
Yes, Professor. I can hear you.
But I gave the answer to that, how far the relevant is. You take any case law, doesn't matter. Either the contract case law, tort case law, or ADR case law, intellectual property case law, or economic case law, doesn't mean the rules are the same.
Okay, Professor.
The rules are the same. Either you drive the Toyota car, or you drive the Mercedes Benz, or you drive the Mitsubishi, or you drive the Ford, which is having the floor gear. Floor gear, I am speaking. Mere gear car. The rules are the same. But only the condition is, some are 4 to 5 gears, some are 6 gears. That's only the change. But the principle is the same. You can press the clutch, then you can put the gear. And slowly you can release the clutch, and slowly you can increase the accelerator. Is it not?
Yes, Prof.
Either you drive any car, doesn't make any difference. Even a lorry, even a truck. Could you forget the driving?
Okay. No.
Once you know the driving, you never forget till your death. When once you know swimming, you never forget the swimming till your death. Yeah, am I right? Okay, expertise may be different, but you can save yourself. Is it clear? Say yes.
Yes, Prof.
If I teach you how to fish by using the stick, the principle is the same. Either you fish in the Tanzania or you fish in the Kenya. Am I right? The techniques of fishing is the same, irrespective of the place. Like 2 into 2, 4 in Tanzania. Does it 5 in Kenya? Answer me. Answer
Pardon, sir.
me.
Pardon, sir.
2 into 2, 4 in Tanzania. Is it the same in Kenya or 5?
It is the same, sir.
Why?
It's a general principle.
It is a fundamental principle, basic principle. It cannot be changed with the change of the place, change of the person, change of the environment. But the law will change from country to country. Which laws? Which laws will change from country to country? If you don't know, you say pass on.
Domestic one.
Domestic laws, what are they? What are they?
Domestic laws.
What are they? Say, pass on.
Like penal codes.
Penal code,
Civil
wherever it is there, same rule and regulations are there.
Yes.
Penal code, even India penal code, IPC, even Tanzania penal code, almost all the same, except the numbering is. What are the domestic laws? If you know it, you tell me. If you don't know it, you say pass on. I will give you the answer. Don't kill the time.
Yes, Prof. We know the domestic laws.
Give me the answer.
The Civil Procedures Code.
Right, Kosa. The Civil Procedure Code and Criminal Procedure Code, Law of Evidence, Indian Penal Code, Tanzanian Penal Code, almost all the same in the India and Tanzania. Or any other country also. Only the tax law changes, the land law changes, the marriage law changes. Are you following me? Say yes. Are you following me? Say yes. Say yes. Raman, I told you, public international law will not change. Jurisprudence will not change. Legal theory will not change. And most of the things will not change. Only few which is based on the land, it will change it. Almost all other general principles are the same. No change. In the law of tort, no change. Of course, law of tort will change it. In the common law country, it is uncodified law. But in the civil law countries, it is a codified law. That would be the changes would be there. But otherwise, it's the cross-boundary courses. Public international law, cross-boundary courses. International humanitarian law, cross-boundary course. Jurisprudence, cross-boundary course. Even the contract general principles are the same. Even you say the refugee laws, almost some of them is vary from country to country, but other things are the same. Do you want to ask anything or shall I close it? I could not get the reply from you, so it's more better I can close it now. So let us meet it whenever I take the class. They will ask you to attend it. With this, I would like to close my today's session and the end of the meeting to each and everybody. Yes, go ahead.
So I spend a lot of time working on social media for my clients. I create a lot of video content